Fair housing is where ethics, law, and practical day-to-day real estate practice meet. In the previous section, you learned that modern real estate ethics are not just a good idea, they are legal imperatives. Fair housing laws are one of the clearest examples of this principle. A licensee who follows the law but ignores the spirit of fair housing is at risk of complaints, lawsuits, and serious damage to their reputation. A licensee who understands both the legal rules and the ethical goals of equal opportunity becomes a true professional in the eyes of consumers and regulators. Fair housing laws, sometimes called equal opportunity housing laws, are designed to give all people a fair chance to live where they choose, so long as they can afford the housing. These laws apply to the purchase, sale, rental, advertising, and financing of residential property. In practice, this means a licensee cannot treat people differently because of who they are, who they live with, or whether they have a disability. The law focuses on the person's ability to qualify for the housing, not on personal characteristics unrelated to creditworthiness or tenancy. At the national level, federal fair housing law sets the minimum standard that applies across the country. States then build on this foundation, sometimes adding extra protected classes or enforcement tools. Local governments also affect fair housing through zoning and land use decisions, which must be made in a way that does not discriminate. A modern real estate professional needs to be comfortable navigating all three layers: federal, state, and local. Federal and state fair housing laws. Federal law provides the core framework. The earliest piece of federal fair housing legislation was the Civil Rights Act of 1866. This statute prohibits discrimination in the sale, rental, inheritance, and conveyance of real property based solely on race. Although it is an older law, it is still powerful. Because there are no exemptions under this statute, it can reach private conduct that might be exempt under later laws. The Civil Rights Act of 1964 advanced the broader civil rights movement, but did not fully address housing discrimination. Persistent segregation, riots in cities like Detroit, and public campaigns such as the Chicago Freedom Movement showed that additional action was needed. This led to the Civil Rights Act of 1968, whose Title VIII is known as the Fair Housing Act. The Fair Housing Act made it illegal to discriminate in housing based on race, color, religion, or national origin. Later amendments added sex, disability, and familial status families with children as protected classes. The principal protected classes under federal fair housing law are race, color, religion, sex, national origin, disability, and familial status. Familial status protection includes households with children under 18, pregnant women, and people in the process of securing custody of a minor child, such as adoptive or foster parents. Disability protection covers physical and mental impairments that substantially limit one or more major life activities, such as hearing, mobility, visual impairments, chronic mental illness, or serious medical conditions. States have enacted their own fair housing laws that generally mirror federal law but may add additional protections, such as sexual orientation, gender identity, or source of income. Because state laws differ, it is essential for licensees to know their own state's list of protected classes and any additional enforcement procedures. A practice that might technically be permitted under federal law could still be illegal under a broader state statute. Fair housing and local zoning. The Fair Housing Act does not replace valid local zoning, but local governments must apply zoning and land use rules in a non-discriminatory way. A city, for example, cannot use zoning to keep group homes for people with disabilities out of a neighborhood just because of community prejudice. It cannot zone multifamily housing out of an area as a way to keep families with children or low-income residents away. Municipalities must make reasonable accommodations in zoning and land use policies when necessary to afford persons with disabilities an equal opportunity to use and enjoy housing. This connection to zoning is important for real estate professionals because buyers and developers may rely on your understanding of how land use and fair housing interact. When a local decision appears designed to exclude protected groups, that decision may be vulnerable to challenge under fair housing law. Enforcement foundations, executive orders, and court decisions. Historically, even strong laws were sometimes poorly enforced. For example, the Civil Rights Act of 1866 was only marginally enforced for many decades. In 1962, Executive Order 11,063 was issued to prohibit discrimination in residential properties financed or assisted by federal programs, such as FHA and VA. This order was important because it tied fair housing enforcement to federal funding. If a property received federal assistance, it had to comply with non-discrimination requirements. In 1968, the Supreme Court's decision in Jones v. Mayer gave new life to the Civil Rights Act of 1866. The court held that the statute bans all racial discrimination in the sale or rental of property, including private transactions. This means that even if a property is exempt from certain provisions of the Fair Housing Act, racial discrimination can still be challenged under the 1866 law. For licensees, the message is clear. Racial discrimination in housing is never acceptable, regardless of the property type or circumstances. The Fair Housing Act in practice. The Fair Housing Act, as administered primarily by the Department of Housing and Urban Development, HUD, through the Office of Fair Housing and Equal Opportunity, prohibits a wide range of discriminatory practices in residential real estate. These practices include misrepresentation, unfair services, and steering, as well as more subtle actions that effectively limit housing choices for protected classes. Discriminatory misrepresentation occurs when an agent falsely tells a prospective buyer or tenant that a home is not available, or that the seller will not consider certain financing options because of the protected characteristics of the prospect. For example, telling a family with children that this complex has no vacancies when it does, while showing those same units to households without children, is discriminatory behavior. Discriminatory advertising happens when an advertisement indicates a preference, limitation, or discrimination based on a protected class. This applies to wording, images, and omissions. Advertising that suggests adults only or Christians preferred is illegal under federal law. Even if a property qualifies for a senior housing exemption, the advertising must be worded carefully and must not discriminate based on other protected traits such as race or national origin. Providing unequal services is another common violation. A licensee cannot offer fewer listings, less follow-up, or slower responses to prospects based on protected characteristics. If your standard practice is to show a pre-approved buyer multiple homes in a certain price range, you must do the same for buyers of all protected backgrounds. Changing your level of effort based on race, religion, or other protected traits is discriminatory. Steering is the practice of directing buyers or tenants toward or away from certain neighborhoods based on protected class. Steering can be overt, such as explicitly telling a buyer, "You wouldn't be happy in that neighborhood because most residents are from a different country." It can also be subtle, such as only showing families homes near one school based on assumptions about what's best, while never offering other neighborhoods that might also meet their needs. Steering deprives clients of the chance to make their own choices based on objective criteria and is a serious fair housing violation. Blockbusting occurs when someone, often a real estate professional or speculator, attempts to cause panic selling by suggesting that members of a protected group are moving in and that property values will drop. Telling homeowners, "You should sell now before more of that group moves in. Values will crash," is a classic blockbusting scenario. This behavior not only violates fair housing laws, but can destabilize entire communities. Redlining is the practice of denying or limiting loans, or imposing different terms, based on the property's location, rather than the applicant's individual creditworthiness. Historically, lenders would draw literal red lines on maps around certain neighborhoods and refuse to make mortgage loans there, often because of the racial or ethnic makeup of the area. Today, fair financing statutes, monitoring requirements, and enforcement by regulators are designed to identify and prevent redlining. Fair housing law also prohibits restricting participation in multiple listing services, MLS, on a discriminatory basis. MLS access must be available using unbiased membership rules. Refusing participation based on race, religion, or other protected traits is illegal. Reasonable accommodation, disability, and familial status. Amendments to the Fair Housing Act added protection for people with disabilities and families with children. For people with disabilities, housing providers must permit reasonable modifications and reasonable accommodations when necessary for equal use and enjoyment of the property. Reasonable modifications are physical changes to the dwelling or common areas, such as installing grab bars, widening doorways, or adding a ramp. Usually, the cost of the modification is borne by the tenant, but the landlord may require restoration when the tenant moves out, if reasonable. Reasonable accommodations involve changes to rules, policies, or services, such as allowing a service animal despite a no pets policy, or assigning an accessible parking space near the entrance. Familial status protection means that landlords and associations generally cannot refuse to rent to families with children, charge higher security deposits because of children, or segregate families into certain buildings or floors. Rules to protect safety, such as requiring young children to be accompanied by adults at pools, are allowed, but they must be reasonable and not used as a disguise for discrimination. The law also recognizes housing for older persons exemptions. Certain communities designed for seniors can lawfully limit occupancy based on age, such as developments intended solely for people 62 years or older, or communities where at least 80% of units have at least one occupant who is 55 or older, and that follow specific rules and verification procedures. Even in these communities, discrimination based on race, color, religion, sex, national origin, or disability is still prohibited. Exemptions and their limits. While the Fair Housing Act is broad, it does contain specific exemptions. For example, an owner of a single-family home who owns only a small number of houses and sells or rents without using a broker and without discriminatory advertising may be exempt from some provisions. An owner-occupant renting rooms in a small building of 4 or fewer units may also fall under an exemption. Additionally, private clubs and religious organizations may sometimes rent or sell non-commercial lodging to members on a preferential basis. However, even when an owner or property falls within a narrow exemption, advertising rules still apply. A landlord renting a room in their own home cannot publish discriminatory advertisements. Similarly, racial discrimination can still be challenged under the Civil Rights Act of 1866. As a result, licensees should never rely on exemptions as an excuse to participate in discriminatory conduct. The Equal Opportunity in Housing poster and HUD enforcement, HUD requires brokers and many housing providers to display the Equal Opportunity in Housing poster in conspicuous locations in their offices. The poster signals that the brokerage is committed to fair housing and complies with the law. Failure to display the poster may be treated as evidence of discriminatory intent in an enforcement proceeding. HUD enforces fair housing through investigations, testing, and legal actions. Individuals who believe they have been discriminated against can file a complaint with HUD's Fair Housing Office, generally within 1 year of the alleged violation. HUD investigates, attempts to resolve the dispute, and if necessary, brings the case before a HUD administrative law judge, or refers it to the Department of Justice. In addition, complainants may file lawsuits in state or federal courts, usually within 2 years of the alleged violation. HUD also uses testers, individuals who pose as renters or buyers to see whether they receive different treatment based on protected characteristics. This can reveal inconsistent statements, selective showings, or suspicious patterns that would not be obvious from paperwork alone. If discrimination is proven, penalties can include actual damages, civil fines, attorney's fees, and orders to take or stop certain actions, such as requiring a landlord to rent to an applicant who was wrongly rejected. For licensees, sanctions may also trigger state disciplinary action against their licenses. Fair financing laws. Fair housing principles extend into mortgage and consumer credit. The Equal Credit Opportunity Act, ECOA, requires lenders to evaluate applicants based on credit factors, not protected characteristics. Lenders may not deny credit or offer different terms because of race, color, religion, national origin, sex, marital status, or age, provided the applicant has the legal capacity to incur the obligation. ECOA also requires lenders to give applicants reasons when credit is denied, allowing them to understand and correct issues, such as errors in their credit reports. The Home Mortgage Disclosure Act, HMDA, requires many lenders to report data about where they make mortgage loans. Regulators and the public can analyze this data to identify patterns that might suggest redlining or geographic discrimination. These financing laws work alongside the Fair Housing Act to ensure that access to mortgage loans is fair and impartial. The Americans with Disabilities Act and real estate. The Americans with Disabilities Act, ADA, complements fair housing law by focusing on access to employment, government services, public accommodations, and commercial facilities. While the ADA generally does not apply to purely residential buildings, it often applies to the public or commercial parts of real estate, such as leasing offices, hotel lobbies, restaurants, and retail spaces. Places of public accommodation, such as hotels, restaurants, and health clubs, must be accessible to people with disabilities. This includes features such as accessible paths of travel, ramps instead of or alongside stairs, properly marked parking spaces, and bathrooms designed for wheelchair use. Existing buildings may be required to remove barriers when doing so is readily achievable, meaning it can be done without much difficulty or expense. Newly constructed public accommodations and commercial facilities are generally required to meet accessibility standards from the beginning. Commercial facilities, such as warehouses or factories not open to the public, must comply with ADA standards for new construction and major alterations. While the ADA's scope is distinct from that of the Fair Housing Act, both bodies of law reflect the same core principle. People with disabilities should have equal access to opportunities, services, and spaces. Fair housing and client discrimination. Fair housing laws apply to both clients and professionals. A seller might ask a licensee not to show the property to certain groups or to reject offers from certain buyers based on race, religion, or family status. If the licensee complies, both the seller and the licensee can be held liable. A professional must politely but firmly refuse to participate in discriminatory actions and should be prepared to terminate the relationship if the client persists. Examples of client discrimination include rejecting a full-price offer because the buyers are from a particular protected group, withdrawing a listing to avoid selling to a qualified buyer, or accepting a lower offer to avoid selling to a family with children. In each case, the licensee must remember that their first duties are to the law and to ethical standards, not to a client's unlawful preferences. Review summary. Fair housing laws translate the ethical commitment to equal treatment into enforceable rules of conduct. They prohibit discrimination in the sale, rental, advertising, and financing of housing based on protected characteristics such as race, color, religion, sex, national origin, disability, and familial status. Federal law sets minimum standards. State laws may add extra protections, and local governments must enforce zoning and land use rules in a non-discriminatory way. The Fair Housing Act bars practices such as misrepresentation, discriminatory advertising, steering, blockbusting, redlining, and unequal services. Amendments and related laws protect people with disabilities, families with children, and through statutes like ECOA and HMDA, borrowers seeking fair access to mortgage credit. The ADA adds requirements for accessibility in public and commercial spaces related to real estate. Exemptions under fair housing law are narrow and never authorize racial discrimination or discriminatory advertising. SHUD enforces fair housing through investigations, testing, and legal proceedings. For real estate professionals, understanding and following fair housing laws is both a legal obligation and a central part of professional ethics. Discussion. Why is fair housing considered both a legal and ethical obligation for real estate professionals? Answer: it is legal because federal and state laws require equal treatment and prohibit discrimination in housing. It is ethical because real estate professionals hold a position of trust and must treat all people fairly, protect vulnerable consumers, and support integrated, inclusive communities. How does steering harm buyers? Even if an agent believes they are helping, answer: steering limits the buyer's choices to certain areas based on the agent's assumptions about where the buyer belongs. This deprives the buyer of the opportunity to evaluate all appropriate properties, reinforces segregation patterns, and violates the buyer's right to choose housing based on objective information and personal preferences. Why is it important for licensees to understand the difference between fair housing exemptions and the broader Civil Rights Act of 1866? Answer: some small-scale situations may be exempt from certain Fair Housing Act provisions, but racial discrimination is never permitted under the 1866 law. A licensee who assumes an exemption allows racial discrimination may still face serious liability. Understanding how the laws fit together prevents dangerous misunderstandings and keeps practice within legal and ethical boundaries. How do fair financing laws like ECOA and HMDA support the goals of the Fair Housing Act? Answer: ECOA requires lenders to evaluate credit applicants fairly, without discrimination, while HMDA requires reporting of loan data to monitor for geographic patterns like redlining. Together, these laws help ensure that qualified borrowers from all backgrounds and neighborhoods have equal access to mortgage credit, which is essential for meaningful equal opportunity in housing. Closing remarks. Fair housing lessons are not just test topics. They are the day-to-day reality of professional practice. Every conversation, showing, advertisement, and recommendation presents an opportunity either to uphold or to undermine equal opportunity. As you continue through this chapter and into future topics like agency, disclosure, and risk management, remember that fair housing principles should be woven into every task you perform. Mastery of these concepts protects consumers, safeguards your license, and supports your long-term success as a trusted real estate professional.